Hi, folks. Welcome to our ConVal decision webinar. My name is Casey. I am the Outreach and Engagement Director at the School Funding Fairness Project. I'm going to, as folks join the meeting here, just take a couple minutes to review the agenda while we wait for our audience to join. If while I'm doing that, people would like to introduce themselves in the chat, maybe put your name, what town you're from, and just a note about kind of what you're hoping to get from this event this evening. You can do that while I go through the agenda. So we'll hope to wrap this up around 7 o'clock. For the first 20 minutes here, we will hear from Michael and Elizabeth, who were the lead attorneys on the ConVal case. And then I will turn it over to our executive director, Zach Sheehan, who will talk a little bit about what we can expect from the legislature moving forward on this issue in 2026. And then I will talk for a couple of minutes about interfacing with the legislature and some actions that you can take to help move the needle on this. And then we will move into Q&A. So I want to talk quickly about what our plan is for Q&A here. So if you're on this call, that means you have registered in advance for it and had the opportunity to submit a question. So we have gone through and pulled out the most commonly asked questions. So we will run through those. If you have a burning question or a comment that you would like to put in the chat, School Funding Fairness Project staff will be keeping an eye on the chat, and we will pull out any questions that would be beneficial to the group. So feel free to put questions and comments in the chat as we're going. And if there's like a large volume of questions that we do not get to, we'll answer those after the fact. In terms of follow-up, what will happen after this webinar that's being recorded. And in the morning, I will be sending out an email to everybody who's on this call and who's signed up that will include the slide decks that Michael and Elizabeth and Zach will be using along with the recording and other relevant links for action items that you can take. So with that, thank you all for being here. And I'm going to go ahead and turn it over to Michael and Elizabeth to get us started.
Yes, thank you very much. Michael Tierney, I was one of the attorneys together with Elizabeth Ewing, who have been litigating this case for the past 7 years. I know that we were not the only ones who were involved in this case. There's probably over a dozen attorneys that have been involved in this case. From the Nashua School District, we had Steve Bolton with us at trial. We had Dean Eggert, who was very instrumental in this case. But the people who were most instrumental in this case were all of the superintendents, all of the business administrators, all of those school employees that worked tirelessly for several years in order to prove this case and make sure we had all of our I's dotted and all of our T's crossed. I think when we talk about this case, it's frequently called the ConVal case or ConVal v. State. And the ConVal School District started this case back in 2018. It at first was only ConVal before several other school districts joined. And by the time we got this case fully before the court in 2021, we had large school districts, we had small school districts, we had urban school districts, we had rural school districts, because education funding affects everyone. It affects everyone throughout the state, and the state was not meeting its constitutional obligations for anyone in the state. And this decision is really huge because it does affect everyone, and it cements what we have known and what we have argued for so many years, which is that the state is not meeting its obligations anyway. So, Kentucky Valley School District v. State, I would love to be able to go through all of the different districts who joined ConVal, all the different superintendents, all the different business administrators, but I know that we're limited for time. Just please know that all of your help was invaluable. What did this case do? What has this case accomplished? The most important thing that it has accomplished is its reaffirmation of the Claremont and Londonderry progeny, which hold that there is a right under Article 83 to a fully state-funded education. This is something that you hear people argue about. It's something that some people have their own personal opinions about, but the New Hampshire Supreme Court has clearly held in many previous cases and in this case that New Hampshire has a constitutional requirement that the state fully fund the education. Very important to have that holding crystal clear. Now, what is new in this case? What's new in this case is that base adequacy can be challenged independently. Most of you already know, but for those of you on this who don't know, base adequacy is that cost that is necessary for any student in order to obtain an education, because students are different. They have different learning styles. They have different learning needs. There are some students that need more. There are some students who are frankly more efficient to educate. And when we're talking about base adequacy, we're talking about the least costly to educate student. So what is that minimum base amount for somebody who does not have any additional needs to be able to receive an adequate education? Now, another important advancement in this case is that the state had been arguing that there is some sort of hypothetical, theoretical cost where it is the absolute minimum, that's all they need to fund. And the Supreme Court made very clear, as we had been arguing for many years, okay, that the universal per pupil amount of base adequacy is not the lowest possible cost, but rather the cost necessary to provide an education to each and every student throughout the state of New Hampshire. So the state can always overfund schools. They can never underfund schools. They need to provide enough funds and base adequacy in order to provide an education for each and every student throughout the state.
So in other words, that can sound sort of contradictory because we're talking about base adequacy, which is the least costly to educate child, but we're also talking about the least costly to educate child in the most costly district, if that makes sense. So that is not students who need additional help through special education, but it's also not students in the most efficient school districts, like very urban areas where it's less expensive, briefly, because of the economies of scale to educate kids.
One of the other things that was very important in the Supreme Court's decision is the Supreme Court clearly held that it is a proper judicial function for a court to determine those components that are necessary to provide an education and the costs of those educational components. That those determinations are properly a judicial determination. It's something that the legislature can make a determination, but that the judiciary has a proper role in order to make sure that constitutional obligations are met to confirm that all the components are being funded at their proper cost. Now, what are these components? The components are going to include some of the more obvious ones, such as teachers and other staff and transportation, facilities in which to learn, and the maintenance of those facilities. The state had argued that it wasn't required to pay for such necessary staff such as nurses, and that it wasn't required to pay at all for the facilities in which students are learning, or for the transportation in order to get those students to school. Not even the transportation which the state requires by statute that our school districts provide. This was one of the arguments that the state has been consistent about for the past 7 years, and the Supreme Court made very clear, no, transportation, facilities, nurses they're all necessary in order to obtain an education in our school districts, and so the state is required to fully fund them. Another very important part of this case is that our school administrators, our superintendents, our business administrators, our teachers, our department heads, all of these folks who spend each and every day and have for many years worked on running the schools and determining their costs and budgeting, they're proper experts to determine the necessary components, and they're proper experts in order to determine the necessary costs. The state had argued we needed to hire some out-of-state expert who was a professional court expert, and we said no. The people who know how to run New Hampshire schools, the people who know how to make a school budget, are the people who do that each and every day. Our school personnel, they are the best experts. The Superior Court agreed, and so did the Supreme Court, that these are the best experts. Now, the Supreme Court, and I gave a quote right here, held that the trial court's declaratory judgment calculation was conservative, supported by the record, and eminently reasonable. It's important to remember that the trial court did not say this is absolutely the exact dollar figure that is the cost of an adequate education. Rather, the trial court bent over backwards to be as absolutely conservative as possible to make sure that the trial court wasn't overstepping its bounds, and it was trying to come up with the lowest possible number so that it was not overstepping. The Supreme Court also affirmed the trial court's injunction to the extent that it established a conservative minimum threshold of that $7,356.01, which base adequacy aid funding must exceed. There's been a lot of newspaper reports and other press accounts about how the Supreme Court somehow struck down the injunction. If you haven't had the opportunity to read the Supreme Court's decision, I highly recommend that you do. The injunction was not struck down. The injunction that the state has to provide more than $7,356.01 in base adequacy was absolutely upheld by the Supreme Court. That's why this is such a big win in this case. The Supreme Court also explained that conservative minimum threshold is not overstepping the judicial bounds. It's not intruding on legislative powers because this court wasn't determining the exact universal per pupil cost. It was trying instead to find that conservative minimum threshold. It also didn't require the state to take any particular action. Okay, the state can come up with all sorts of legislative remedies that could potentially meet constitutional requirements. It instead just set what that absolute minimum threshold is that base adequacy must exceed. It also, weighed all the evidence and all the deference that's owed the legislature, given the history of education funding in the state for the past 30 years. And so it wasn't looking at this decision or even the 7 years of history of this particular case, but rather the 30 years of history of this case and all of the cases that came before. And I apologize, I probably should have pointed this out earlier, but you see on the lower right-hand corner, paragraph numbers. Those are the paragraph numbers from the Supreme Court's decision that you can go back and look at where the Supreme Court actually said what the Supreme Court actually said. So if you wanted to go back on one of these points that I'm making and see what the Supreme Court said at a greater length, those paragraph numbers are in the lower right-hand corner. The one thing that the Supreme Court did reverse was the order that the state immediately pay the increased amount. The Superior Court ordered the state make that payment immediately. as opposed to in other cases where injunctive relief perhaps provided the state 30 or 60 or 90 days to comply. In fact, the Supreme Court noted that in other cases, injunctive relief has even provided the state with as long as a year to comply with the Supreme Court's decision. And so the order that payment must be made immediately was struck because of that word immediately is, well, really, really, really quick. It's almost impossible to make the payment immediately because as soon as you say, well, the payment hasn't been made. And the final thing the Supreme Court held is that the trial court needs to determine what amount of the school district's attorney's fees the state must pay for. Clearly, you don't have an order for payment of attorney's fees in a case that you lose, only in those cases that you win. And the ConVal decision was a big win for the school districts, for the taxpayers, and for students all over the state of New Hampshire. Now, there were two justices who dissented, who had argued that the plaintiff should have challenged base adequacy and differentiated aid together. I don't think those two justices fully understood that as part of this trial, as part of the pre-trial motions, it was shown and the evidence was undisputed that all of the differentiated aid categories cost more than the aid that is being provided. So, for example, the cost of special education services being provided in each and every district far exceeds the amount of special education aid being provided by the state to that particular district.
And in fact, the majority opinion notes that evidence that was in the record about the disparity between the amount of differentiated aid and what those needs actually cost. It's in one of the footnotes. I just don't have it memorized.
Now, there were two other dissenting opinions, which makes a Supreme Court case kind of confusing when you have a dissent. Those two justices actually agreed with a majority opinion about everything except for the striking down of the word immediately. Those two justices would have upheld the Superior Court's decision in its entirety, including the order that there be immediate payment of the increased funding amount. Those two justices felt that enough time had been spent, the state has not met its obligation, and that staying the judicial hand in the face of continued violation of constitutional rights makes the courts vulnerable, becoming complicit in the deprivation of those rights. So that was the decision. The state has filed a motion for reconsideration, and in their motion for reconsideration, they make the same arguments that they've made before, which is generally that the court has overstepped its bounds, and that the court should have instead ruled that the state does not have to fund every part that is necessary and required to provide an adequate education. We obviously have filed an objection pointing out that the state's arguments are contrary to 30 years of precedent on education funding. And even if they weren't contrary to precedent, they waived any challenge back in their oral argument in 25 years ago. So I believe I have managed to stay under time, and I will turn it back over to you, Casey.
Fantastic. Thank you so much, Michael and Elizabeth. I'm going to just remove your spotlight here and then replace you with the executive director of our organization, the New Hampshire School Funding Fairness Project, Zach Sheehan, to talk a little bit about the legislature and what we can expect moving forward in 2026. Zach, turning it over to you.
Awesome. Thank you, Elizabeth and Michael, for giving that overview. Hi, everyone. My name is Zach Sheehan. I'm the Executive Director of the New Hampshire School Funding Fairness Project. For those of you who might not know about us, we're a nonprofit organization based in New Hampshire. Our staff kind of come from all over the state, small 5-person team. I've been around for about 5 years. And a lot of what we do is educating people around the state about school funding in New Hampshire, property taxes, the ways in which we think the system is inequitable. And we talk a lot about the school funding lawsuits. ConVal has been a big piece of what we talk about, explaining what it is to folks and kind of connecting what the arguments being made in the ConVal lawsuit and another school funding lawsuit, the Rand lawsuit, which I'll mention briefly in a little bit, where those play into the legislature. So our job is educating folks about these issues and then engaging people and helping them engage with their elected officials and advocating for policy change that we believe would help alleviate some of these inequities in the states. We play a different role than the folks actually on the lawsuits. We're not formally involved in any of the lawsuits, but we talk about them a lot and they intersect a lot with our work. So I'm just going to run through a few slides. You'll see a few of these are similar things that Michael and Elizabeth were just referencing. Really, what I want to help give people a context of, and then lead into some of the things Casey is going to be reviewing is what has been the reaction to this lawsuit, and how are some of our legislative and state leaders talking about the lawsuit, and kind of what can we learn from that as we look towards the next legislative session, right, which is the opportunity for the state to address these issues. What can we look towards that heading into it? So I'm going to kind of show a handful of quotes from some of our, just the top state lawmakers and leaders in the state in the reaction, kind of talk through some of the areas in there. So this is the statement from Governor Kelly Ayotte the day that the ConVal decision came out. And this is also something that we see a lot of folks talk about often, which is that New Hampshire is one often top 10 in the country when it comes to total amount of money that we spend on our public education system. That is true. In general, we do spend a lot of money on our public education system on average, and we have really good schools all across the state. The challenge here, right, and the thing that we talk about a lot, and really kind of, in my opinion, one of the crux elements of these school funding lawsuits is who is paying for that? Where does the state's obligation line up with the local obligation for funding that adequate education that has been ruled in the Claremont lawsuits, upheld in the ConVal rulings that Michael and Elizabeth were just reviewing? So this is, for folks that have seen some of the work we've done, we love this pie chart. This is a breakdown of revenue to our public schools from all the different sources. And I show this to show that in New Hampshire, yes, we do spend a lot of money, a high amount on our public education system on average, but who's paying for that is largely property taxpayers. In fact, the state contributes the smallest share of funding for our public education system out of any other state in the country by quite a long shot. You'll notice here that, and I'm not going to get to this is for a different topic, but swept and local property taxes are the same color there. That's because in New Hampshire, swept, it's a statewide property tax, but it's raised and retained locally, so it's effective a local property tax. So while we do spend a lot, this case and other arguments lining up with our work is talking about where is that state's responsibility, right? And should it be larger than that 20%, and in what way? Another thing we've been seeing a lot, and this was covered, kind of the pieces of the ruling, is why wasn't differentiated aid part of the case? And people trying to kind of do some creative math to say basically that if you lumped in all the differentiated aid categories, just tweaked them around, reclassified them, right? So just take all state education spending and just redefine it as base aid, that would satisfy the court ruling. Michael and Elizabeth laid this out, but also the Supreme Court actually went into explicit detail that this would not satisfy that, and that they by reclassifying differentiated aid for students, for example, receiving special education services, would defeat the purpose of that aid category if you just reclassified it as base aid. We've also seen, a number of kind of reactions to this that have a few pieces to it. And so one is that, well, hey, since the case was filed, the state legislature, I mean, Michael, I think you referenced 7 years, since the case was filed, right, school funding has been increased, which is true. There's been some modest increases, including a 2% increase this year. And so legislative leaders basically saying, like, the case doesn't make sense anymore because we've already increased funding, right? Judge Ruoff in the Superior Court actually had a really interesting exchange where he asked the state, he said, okay, so if I rule right now that base adequacy is unconstitutional, and I don't give you a number, and you turn around and increase it by $1 per student, it's technically a different number than I ruled on, but nothing's actually changed, right? And so what would be the point of that? And he, kind of asked the state, and there's an exchange there, and that goes back to this minimum conservative threshold, right? It's not the court saying you must do, here's the exact number. It's you got to hit this bar, because when we don't put a number in, past 30 years show that the legislature, is not increasing based on a amount that actually makes sense. We also see another kind of piece. This again goes to this base adequacy, which is what the ConVal case was about, right? Versus other aid categories that come from the state. And legislative leaders kind of putting up this false choice and saying, well, the only way we're going to be able to pay for this is to wipe out all of our other aid categories and lump it into base aid. And I just want to point out, kind of with thinking forward to what are going to be the conversations at the legislature next session here in Concord about how legislative leaders deal with this. That would be an active decision to do that, right? There are lots of paths forward. The case, that was not what the case was about. And I don't think, that anyone involved in the case would advocate for eliminating all other state aid just to pay for this one category, just to satisfy the ruling. And so we have seen kind of a lot of, rhetoric around that. We've also seen a good amount of rhetoric around, the, ConVal being kind of inappropriate or unhelpful lawsuit ruling because it's just a one size fits all, doesn't take into account. Again, Michael and Elizabeth kind of laid out where differentiated aid played in and what this case was actually about. It was not saying, if you solve this, you've solved everything. We don't need to look at other elements of the school funding system. It was really zeroing in on this kind of critical base aid element. Another piece I'll pull out here, which was both in the Superior Court ruling and again in the Supreme Court ruling, was over this entire case, the state never once provided evidence that the amount of money they were providing was enough. Think about that for a second. 7 years, millions of dollars, and out-of-state lawyers, staff time for state attorneys, right? They never once said, no, we're actually providing enough. Here's our math. No, actually, we're providing enough. Here's why we think that's true. Never once said the amount of funding they're providing is enough. And the Supreme Court pulled that out again and said you provided no evidence, and you actually went so far as to say you don't know what the cost is, and you don't know how to go about finding it. Here's the quote from the Supreme Court pulling that out, saying that you spent all your state's testimony, all your witness time just going after the ConVal numbers and the trying to discredit their experts, and did not actually provide evidence about what you could the actual evidence for the base adequacy. This is that quote from the Superior Court ruling. And I emphasize these pieces not to be pessimistic, although oftentimes the way we talk about this can be a little daunting. But I emphasize instead, we have a really incredible opportunity here, right? This ruling is not going to solve everything on its own, right? It doesn't just magically make things, different, right? But what it does is it really sets a very different bar, and it sets a very different opportunity for folks to engage with the legislature, for the legislature to say, all right, that's the Supreme Court interpreting our Constitution, interpreting our constitutional obligations. How are we going to go about doing that? One last piece, and Casey, we are flying through this, so we're gonna have plenty of time for questions. But one last piece, and maybe I'll open it up if Mike and Elizabeth had a few things they wanted to add before we go on questions. But one last piece I'll point out, just again, kind of a little bit of what's being said about this ruling versus what could we actually do to sit down and figure out how the state would go about fulfilling this obligation, fulfilling this ruling. This is the same chart I showed at the beginning. A lot of folks have classified this ruling as, it's a mandate that the state has to increase public education spending by, about $500 million. Really what this is it's a ruling, and the case is about, again, who is paying for that, right? Nothing in the case is saying that we should increase spending across the board by X amount. It's saying, where's that responsibility? Another way to think about that is it's not necessarily about increasing the size of the pie, it's about shifting that. An oversimplification of that would be shifting that from the state, from local property taxpayers to the state, following that base adequacy is at least that 73.56 number. Again, all of these pieces, right, line up to how is the legislature going to engage in this conversation this coming session? And I don't know if, there's not, like Michael and Elizabeth pointed out, there's not like a deadline like tomorrow on it, right? But the next time in which this could really be addressed is this upcoming legislative session. So I'll wrap it up there, Casey, and see if Michael, Elizabeth, since we're doing great on time, I want to add anything before we jump into some questions.
I would just recommend that anybody who wants to understand what the Supreme Court held actually read the decision. I mean, I think the Supreme Court's decision is a terrific decision. It very strongly affirms what the Superior Court decided in this case, and read the decision. I recommend highly that you actually read the decision.
Fantastic. Thank you, Michael and Zach. I'm going to talk quickly about engaging with the legislature and what you can do to engage on this issue with the legislature and with our organization before we move into Q&A. So this ruling, as we've learned here, is a major win for public schools, and it forces the state to finally confront its responsibility to fund an adequate education. It is no secret that the legislature has not only been ignoring the previous rulings on this matter, but more and more they're ignoring the people who have voted them into office. So the legislature has continually tried to get around addressing this. This year alone, they tried to pass a resolution that would have tried to limit the judicial branch's involvement in ruling that the legislature must act at all. They tried to impeach. They put legislation forth that attempted to impeach the judge for both the ConVal and Rand case rulings. There was legislation that would have imposed state level budget caps and would have taken away local control from school districts on their spending. And one other thing that was up in the legislature this session was legislation to gut the definition of an adequate education, removing things like government history and economics from that definition. So in light of these bills, people have contacted the legislature about school funding like they never have before. When they tried to gut the definition of an adequate education, over 30,000 Granite Staters signed in opposition to this bill, and that was somebody from every single city and town in the state. This is the most people ever that we know of to sign in opposition to legislation. During the hearings for the budget this session, so many people testified at the House on their lack of action on education funding that Chairman Weiler, not once but 2 times, made attempts to silence the advocates that had shown up and took time out of their workday to use their voices on this issue. And overall, the legislature has demonstrated time and time again their lack of urgency around the issue and have shown the people who voted them into office that they don't care about what they have to say about school funding. So now that the Supreme Court has made this ruling, lawmakers need to make a plan to deliver a school funding system that puts students first and stops downshifting the burden to local property taxpayers in compliance with this ruling. And the most important thing that you can do on this call, if you're looking to take action, is talk to your legislators and continue to show them that you're watching them and that you're taking this ruling seriously and expect them to do the same. And action that you can take right now is going to the link that someone from our team will paste in the chat and that we'll send out after this webinar, where you can send a message to all of your state representatives and senators with one click. And to lower just the barrier to entry for that, we have included a pre-written message there, but it's a lot more potent and holds a lot more meaning when you write your own. There are legislators that are on this call with us right now. So you guys have shown up and they see that. So we know, that high volume emails only go so far, but it's a time of year right now when the legislature and schools are out of session. This is an opportunity for us to all together set the stage by showing them that a lot of people are not only here listening, but are going to be holding them accountable to act in compliance with this ruling. So if you're familiar with our organization, you know that we provide a lot of different types of opportunities to engage. So in addition to doing that advocacy tool that we've put in the chat, sign up for our newsletter to stay in the loop about our strategy for engaging with the legislature on this issue and how you can help. And if you'd like to engage more directly with us, I would love it if you reached out to me directly, and I will go ahead and put my email in the chat as soon as I wrap up here. And unless I missed anything there, Zach, I'm going to move us into Q&A. Great. So the first question that we've got is, what does it mean that this decision has no deadline associated with it?
I'm happy to start with kind of like the, from the advocacy side, and then if Mike and Elizabeth want to add in from the kind of technical side. And as you all pointed out, this is definitely something that has been cited a lot, miscited as saying that the injunctive relief in its entirety was struck down. Another way to look at this is that this was the Supreme Court's attempt to be kind of like excessive deference, right? So even though there's decades, and the dissent pointed this out, but even though there's decades of lack of action, there's actually evidence that the legislature does not want to engage with this. One way to look at this is this was the Supreme Court saying, we're really gonna, give you the opportunity and really defer to your power and your purview to solve this. We're gonna really focus on this minimum conservative threshold, but we're not going to put a time frame on it. That was also an argument in the Rand case we saw a little bit, and in the ConVal case, where the state kind of at different points was like, what you're asking us to do is too much, too fast, whatever it was, right? And so another way to look at this is it was the Supreme Court really trying to say, look, we're not giving you a specific timeline on this, but you do need to solve it. And I do know they referenced a few other rulings where the legislature, addressed it within a year or so, kind of saying, hey, maybe that's about the timing that you should be aiming for. So that's kind of my take on it, and we'll be looking, really at what the legislature is going to do this next session. I don't know, Mike and Elizabeth, if there's more nuance there or technicality to it that I might have missed.
Well, I guess the only thing that I would add is that when we're at the Superior Court and the court issued its injunction for immediate payment, the state asked the court to reconsider that and to give it 1 year in order to comply. Now, ultimately, the Superior Court said, no, you have to pay immediately. But what the state was asking for was a period of 1 year. And the pleadings, you can read if that was the state's argument that they needed 1 year.
Great. What prevents lawmakers from ignoring this ruling?
I can start again. I mean, this is the challenge of this issue, right? Is what, where that line on separation of powers is. I mean, I guess in theory, they could just not address it, right? There's now a really much stronger basis for, I'm not gonna promise someone else's work, but like, folks could sue again in the future if this is not addressed. It's really clearly laid out, really clear Supreme Court ruling. In other states, we've seen the courts take kind of more dramatic actions. I personally don't know if that would happen in New Hampshire, but really it's just like it's accountability to the legislature, it's keeping pressure up on them, but that is the delicate balance and the the challenging history of these rulings in New Hampshire's history, the past 3 or 4 decades specifically, where there's been these strong rulings and the legislature has done some things, not much, and then kind of there's been this period, and then folks have come back and brought another lawsuit to try to enforce it. So that's kind of the non-answer answer. I don't know technically if there's additional things that can happen outside of that.
All right. Okay, so next up, and I'm going to lump one more question in here from the chat. So some people are saying that this sounds like judicial overreach. Is this ruling going too far for the courts? And someone in the chat, a question that got a couple of likes just in that same vein is Isn't it a conflict of interest for the executive branch to be litigating a case that is in the purview of the legislative branch? And those are the questions.
I can start with that one if you'd like, Zach, because just like I would recommend that anybody who wants to understand this decision actually read the decision, I would implore anyone who wants to understand Article 83 of the New Hampshire Constitution to read Article 83 of the New Hampshire Constitution. And you will notice that Article 83 of the New Hampshire Constitution does not fit in that section under legislative powers. It does not fit under that section under executive powers. It's in a section all its own because Article 83 is an obligation of the entire state. Article 83, by its express language, okay, requires the legislature and the magistrates in all future governments, okay, this is written over 200 years ago, so the legislature and the courts and the governor, every part of the state is responsible for making sure that this obligation is met. And the court is an integral part of determining whether constitutional provisions are being met with or constitutional provisions are being violated, whether that is education funding or any of the other parts of the New Hampshire Constitution.
I'll just add that if this is something that constitutional nerds are excited about, there was a lot of briefing about this in the Superior Court, and all of those pleadings, I believe, are available publicly as well. That was briefed just around the time of trial in the spring of 2023.
And I guess I would also just add that when the Supreme Court makes a determination as far as what the Constitution means, such as they did in the Duncan case in 2014, sometimes the people of New Hampshire say, no, we want the Constitution to mean something else. And they respond with a constitutional amendment, such as what happened in 2018 that overturned the holding of the Duncan case. In the past 30 years, there have been attempts to amend Article 83 that have all failed. And I think that's because the people of the state of New Hampshire understand that it is an obligation of all of us in order to make sure that we have an educated students across the state of New Hampshire.
Great. Michael and Elizabeth, would you be willing to go into a bit more detail about why this ruling is only about space adequacy when the state provides more funding in other forms?
Sure. So one of the things that we did when we were initially looking at what could be done judicially is we looked at what has happened in other cases in other states. And one of the big challenges with special education funding is that special education funding is tied to individual student needs. Each individual student, based on their disability and their learning challenges, are going to have special education funding needs that are different than the student next to them. That makes it very difficult, very time-consuming, very expensive to litigate to try to determine what that number should be on a macro level. If you look at the states that have tried to do it, they have taken, instead of the 3-week trial we had on base adequacy, much longer and gotten into far greater details that is very difficult, very time consuming, and very expensive. Base adequacy, on the other hand, is something that is inherently knowable and provable. One of the things which surprises some people who don't do it every day is that the cost of teachers is something that you can determine. You know what the salary requirements are such that you get applicants to apply for the teaching positions. You know what the teaching requirements are, the time requirements are, and the number of students you can teach in a day. And if you look at things such as facilities maintenance, that's something that is pretty consistent across the state. It is not that different for different buildings because you need things like electricity, you need things like heat, and if you look at it over, a large section, you can determine those costs. And that's exactly what happened here, is that we looked at all these different components and were able to determine these costs. That's something which the legislature had sort of set up the input method. It was something that some of our experts had looked at that same methodology, and it's something that is knowable and provable. It costs $10,000 to educate a student. You can't really get lower than $10,000 to educate a student, and this is something that can be done and was done.
And to sort of bolster our suggestion that this is knowable, provable fact, the state actually hired their own expert, the legislature did, back in 2019, who determined using a different methodology called the output methodology. And he determined that the cost was $9,964 for base adequacy. So no matter how you sort of go at eating the sandwich, you get to the same place.
And one more thing I'll add in is, relative to kind of like the differentiated aid piece, and I saw this pop up in the chat as well, is, there's another school funding lawsuit, the RAND school funding lawsuit, that does look at those differentiated aid elements more explicitly. And that was a part of the case from the beginning. And so we're waiting on the ruling from the Superior Court in that case. We expect it to come out. Well, every time I give a prediction, the lawyers in the room tell me that I can't and shouldn't predict. But ideally, we think sometime in the next few months, especially given the ruling from the ConVal case is now out. So that will be another kind of piece to look for, is how is the Superior Court, it'll be appealed to the Supreme Court. Where are they thinking? How are they weighing in on those special education, for example, and other differentiated aid elements?
All right. So one question that we got a lot in the pre-submitted questions is how, if at all, do vouchers play into this, since the amounts are in part determined by base adequacy?
I can start there. Like the short answer is, the ConVal case had nothing to do with vouchers, otherwise known as education freedom accounts. The fact that the legislature tied the definition is kind of like outside the purview of the case specifically. If the legislature were to just increase base adequacy without making changes, then that would increase the voucher amount. So that's just kind of like the what would happen if they did that without breaking that link there. So they are intertwined on the legislative side, but not in the ConVal case. Did I get that right, Michael and Elizabeth?
So the ConVal case did not talk about vouchers at all. It was not part of the case.
Where will the money come from to comply with the ruling?
I can start there, or go for it.
Where the money comes from, again, is not something that was decided or explicitly ruled upon in the ConVal case. I do know that a Republican representative from Bedford, Linda Gould, put in this bill this past legislative session that simply increased the SWEP to a statewide level of, I think it was $5 and something like that, such that the SWEP would raise sufficient money to pay for the entirety of base adequacy. That's just one of many options that could be chosen from.
Yeah, and this is, I think, also a central question as to why this issue continues to be so challenging in New Hampshire, is that we're talking about large sums of money that would need to be raised by the state, which again, if directed through base adequacy or other education funding, would and could reduce local property taxes in a lot of communities. There's a number of mechanisms to go about doing that. Probably not one solution that's gonna, just do it right across the board. Statewide education property tax, making that a true state tax, adding in some elements around, homestead exemptions or, based on ability to pay. There's, a number of other taxes that we have in New Hampshire, business taxes. We just eliminated the interest and dividends tax. So like there are revenue sources that are available to engage in this. There's not, I don't think, one silver solution, but just the fact that we have to talk about taxes when engaging this is not a reason to not engage in this, and not a reason that the state should not kind of take this as a serious policy consideration in the next session.
We've got some folks who have taken Michael's advice to take a look at the ruling, and I think this is a helpful question. So the ruling states that we have time. We have time and again reaffirmed our holding in Claremont 1, which is the duty of the state to define, cost out, fund, and ensure delivery. Should the legislature use that as an opportunity to develop legislation that will cover all 4 of those points?
Sure, that'd be great.
All right. So to close us out here, I'm going to direct this final question to Zach, and that is just what can parents and families and folks who are interested in helping do to help move this along?
Yeah, again, I want to just also make sure to emphasize that this is not a simple issue, obviously, and any attempt in either direction, right, to oversimplify this, I think is really missing the point. I mean, the level of detail obviously gone into during the case for the lawyers and the teams working on that, but also the legislative solutions are not going to be simple, are not going to be, broad strokes, are going to need to be, I think a lesson we all can take from both the ConVal and the Rand lawsuit is that, there are answers we can find. I mean, Elizabeth pointed out that 2 totally different methodologies, right? One paid for by the state previous to the ruling, previous to the court case. One, kind of put up by the plaintiffs in the case, came to very similar numbers, and both had a lot of data, research, experts backing them up. And so I think really kind of the push, in our opinion, right, is working to engage with your state level lawmakers, reps, senators, the governor, and really, asking them what's their plan to comply with this ruling. How do you envision going about working on this? How are you going to go about learning about what some of the potential options are? I might have we might have a option that we think would work, or a few, right? But we're just one voice. It's really critical that folks from different perspectives, different parties, different branches of government come together, different parts of the state, and really consider and work on how to address this, not pretend that they don't have to, and not just continue to ignore it. So I think that there's a lot of room and a lot of latitude. And again, I think that this ruling provides a really frankly, a really great opportunity to kind of lift this issue up. But again, this is something we can do in partnership, and it might be in partnership with folks that you agree with a little bit or not that much from different parts of the state, different backgrounds. But I think it's really important to understand and remember that, like, people in New Hampshire, we really care about our public schools. We choose to tax ourselves to invest in them. We have good schools, but the system does not work for everyone, and it works less for some communities. And so it's really important to remember that. And also, any solution that we come up with, gonna have to be bipartisan, gonna have to get broad consensus, right? If it's gonna be lasting and durable. And I think the ConVal case laid out a lot of good evidence, a lot of good methodology, a lot of good experts, right? People who've been doing this for decades. So did the state's 2020 Commission to Study School Funding. So we have a lot of evidence and a lot of work to build on. So I guess I just really encourage folks, and if you want to use the tools that we have, this is some of the thing we do is help folks engage with legislature. But it's gonna take all of us, and it's not gonna be easy. It's not gonna be simple, but it doesn't mean it's not worth digging into it. And I just want to, also really thank Michael and Elizabeth for taking the time to be here. It's super helpful, and just for all the time you and the plaintiffs and the school districts and all the other folks working on the case. I mean, a 7-year trial, that is a lot. And, it was a really, really critical ruling for students and folks all over the state. So really appreciate both your time tonight and over the past 7 years.
Thank you guys very, very much for having us. And I want to echo what Michael said earlier. This decision is a good decision, and it's a good decision because of all of the hard work of our administrators and the districts who invested in it. So thank you to all of you, especially the ones who are here tonight.
Yeah, I'll just echo that. Thank you to everybody who showed up tonight. This is a huge volume of people to be on a webinar like this on an evening in the summer to join to learn about this. So before I close us out here, I will just remind folks about the advocacy tool that we mentioned earlier. If you're interested in having some assistance contacting your reps, that link is in the chat and I will bump that. I will be sending out a follow-up email tomorrow morning that will have the recording of this webinar, and we have a web page up that has, right now it only has a couple of the slides from Michael and Elizabeth on it, but once the webinar is uploaded and processed, that's where the recording will live, and you can feel free to share that around as you see fit. Sign up for our newsletter to stay abreast of all the different opportunities that our organization offers to stay involved. And if you have any specific questions or want to engage with the School Funding Fairness Project more directly, please feel free to reach out to myself. And with that, I'll just say thank you very much to, again, to Elizabeth and Michael for joining us for this, and for Zach, to Zach as well. So thank you all for being here. Bye.
Good night, everyone.